Residential report writing and case studies, Chapter 8, disclosure of scope of work, and something with an A. Assignment conditions. As we noted earlier in this chapter, assignment conditions are conditions that affect the appraiser's scope of work. They include extraordinary assumptions, hypothetical conditions, laws and regulations, jurisdictional exemptions, or other conditions we have addressed extraordinary assumptions and hypothetical conditions in some depth in previous chapters. In this chapter, we will address jurisdictional exemptions and other conditions. These other conditions may be applicable in a wide variety of residential appraisal assignments, many of which will necessitate additional disclosure of the scope of work. Here is what we are talking about. Fannie Mae guidelines with a question mark. In bold it says, if applicable, they are an assignment condition. FHA appraisal requirements with a question mark. Assignment condition. Prospective client requests a 10-year sales history on the subject with a question mark. Assignment condition. Prospective client states that the cost approach must be developed, even if the appraiser deems it not applicable, with a question mark. Assignment condition. Attorney requests an appraisal within a retrospective value from 5 years ago. Assignment condition. Assignment conditions can add to the requirements of USPAP, but they cannot be less than what is required by USPAP, except for jurisdictional exemptions, which we will address in this chapter as well. We will cover several assignment condition scope of work disclosure issues on the next several pages. End of page. Fannie Mae. Fannie Mae designed their suite of forms 1004, 1025, 1073, etc. to meet their own needs. It is unlikely that additional disclosures for extent of inspection would be required for a Fannie Mae lender, unless there are unusual inspection circumstances, such as the property owner refusing an appraiser access to a room. How about if a non-Fannie Mae lender requires use of a Fannie Mae form to report an appraisal? In that case, additional disclosures regarding scope of work may be necessary. Example, a local portfolio lender asks Sally to do an appraisal on a single-family home. This lender does not sell loans on the secondary market. They request that Sally report the appraisal on the current URAR form because their underwriters are familiar with it. Sally does not have to comply with the guidelines of Fannie Mae in this appraisal assignment. In making her scope of work decision, she decides that researching the sales history of the comparable sales is not necessary for the development of credible assignment results. Now she must ensure that intended users are not misled about her scope of work. In the date of prior sale/transfer blanks on page 2 of the form, she inserts "not researched." In the comment section below it, she writes, Appraiser did not research the sales history of the comparable sales, as this was not deemed necessary for credible assignment results for this intended use. This appraisal is not prepared in conformance with the secondary market guidelines of Fannie Mae/Freddie Mac. The lender is now fully aware that the scope of work used by Sally does not include researching the sales history of the comparable sales. By the way, the current URAR form and other Fannie Mae/Freddie forms are not recommended for reporting of appraisals for non-lending intended uses, such as estates, eminent domain, litigation, relocation, etc. An appraiser should not use the URAR form for these other intended uses, even if the appraiser is careful to insert a detailed scope of work statement. There are a number of pre-printed items on the form, such as the statement of intended use, intended users, etc., that are specific to mortgage lending and could possibly result in the intended users becoming confused or misled. End of page.